Helping patients, that of course is what every doctor strives to do. But what does a doctor do when or if a state law prevents that? Well, in North Carolina, one doctor, a Winston-Salem surgeon, actually is suing the state of North Carolina. And now the Locke Foundation has filed an amicus brief, a friend of the court brief, in the case called Singh versus North Carolina Department of Health and Human Services. Jon Guze is the Director of Legal Studies for the Locke Foundation. He wrote this brief, filed in early October, in the Wake County Superior Court. He's here to talk about what it all means. Jon, welcome back to the program.
Thank you, Donna.
Why is the Jon Locke Foundation involved in a court case in North Carolina?
What's at stake in this case is a law we refer to as a Certificate of Need law. Under that law, hospitals and other healthcare providers for a wide range of services, including, in this case, MRIs, have to obtain a certificate of need from the state before they're allowed to provide those services. So in Dr. Singh's case, he can't even acquire an MRI machine without first obtaining a certificate of need. At the time he filed the complaint last year, there were no certificates of needs available. So he had no option of obtaining an MRI to use in his practice under any circumstances.
He works out of Forsyth County. He's a surgeon there and trying to serve his patients. And he has actually been a guest here on Carolina Journal Radio. And in his case, he says, hey, I'm trying to help my patients. And in what I do as being a surgeon, sometimes multiple scans are necessary to diagnose and treat a patient. He also says he could do this at a lower cost. My point, Jon, is that this sounds like it makes common sense. Why would the state of North Carolina believe that state bureaucrats would decide rather than Dr. Singh as to what his patients need?
Well, it's complicated. I mean, part of it is simply that an awful lot of people in government and people even out of government think that government knows best and think that things like healthcare will be provided better and more cheaply under some kind of centralized control. But there's more to it than that. It used to be in the 70s that a couple of federal programs were raising the cost of healthcare to the federal government. We had a cost-plus reimbursement system that was in place for Medicare and Medicaid. That meant that the more services a doctor or a hospital provided, the more money they made and the more the state had to pay for it. And then to deal with that in sort of a ham-fisted way, the federal government passed a law that actually required states to have certificate of need laws if they wanted to continue receiving funds to reimburse Medicare and Medicaid patients. So at the time this current law was passed in 1978, there was a rationale, and that was it. But what happened in the 80s was Congress, for once, actually realized it had made a mistake and changed both of those laws. They stopped reimbursing on a cost-plus basis and moved to a fixed fee per service model, and they also repealed the law that required states to have con laws. At that point, some states, the sensible states, repealed their con laws and went back to letting doctors and hospitals provide the services that they thought their patients needed. That didn't happen in North Carolina. Our law is still on the books and it's still being enforced.
Jon, let's talk a little bit more about what is in your friend of the court brief in this case. Dr. Singh contends in his lawsuit that the Certificate of Need law related to MRIs is unconstitutional. What do you write about that?
Well, we say that he's right. It is unconstitutional. In his brief, which was written, for the record, I should say, by the Institute for Justice, they are providing pro bono legal services for him. They charged the state with 3 counts of constitutional violations. It violates the Due Process Clause, it violates the Exclusive Emoluments Clause, it violates the Anti-Monopoly Clause, and it violates the Equal Protection Clause of the North Carolina State Constitution. We agree with all 3 of those. It does violate those provisions of the North Carolina Constitution.
Does that suggest then, Jon, that Dr. Singh is likely to prevail in his case?
Well, we certainly hope so. The problem we've got here in North Carolina and throughout the country is what's called tiers of scrutiny doctrine. The courts have taken the position over the years, and it's the law here as in many states, that different kinds of rights get different levels of protection. There's nothing in the North Carolina Constitution that says that, or in the U.S. Constitution, but that's what the courts say. And in this case, this has been treated in the past as an economic regulation, and economic regulations get the lowest level of scrutiny, what's called rational basis scrutiny. What that means is if the court can find any possible rational basis for a law, it will uphold it. In this case, with certificate of need laws, that's already happened. In 2010, the Court of Appeals upheld the con law to a constitutional challenge because it said that the findings of fact that were appended to the law when it was passed in 1978 and amended in 1988, those findings of fact were sufficient to provide a rational basis, even though they violate common sense and basic economics, because those findings of fact say that by restricting the supply of medical services, we can reduce the cost and improve the accessibility.
That seems to turn economics on its head.
It absolutely turns economics on its head. Arguably, in the 1970s, there was a rationale for doing that because of these perverse federal laws, but those laws are gone. At the present time, there's no possible justification for making such an irrational assumption. And one of the things we argue in our brief is that the court shouldn't simply defer to the legislature on this. It's got to take a look at the facts of the matter. And we've attached as an appendix a long list of studies, all of which were published since the Court of Appeals handed down that decision in 2010, dozens of them, all of which find that, just as you would expect, in states with con laws, healthcare, the services covered by con laws cost more, they're harder to obtain, there's fewer of them. And we think the court needs to take that into consideration.
Jon, as you studied this case and Dr. Singh's assertions in his lawsuits, and then as you reviewed the North Carolina Constitution and did your research, what did you come away with believing is the strongest component of the case to say that Dr. Singh is being unfairly kept from providing MRI scans to his patients?
I think his strongest argument is his argument under the North Carolina State Constitution's anti-monopoly clause. That clause was originally, and I've written a paper about this, that clause was originally added to the state constitution in 1776 for the specific purpose of preventing the awarding of or the grant of exclusive privileges to individuals or groups. That's what we have here. It's exactly the kind of monopoly that the clause was written to prevent, and it's perfectly on point. I think he should prevail on that, if nothing else.
Now, what happens to this case from here? You filed the brief in the last day of September. What happens? When will it be heard?
The schedule right now calls for a hearing the week of October 21st. At some point after that, hopefully not too long after that, the court will make a decision whether to dismiss the case or not. Whatever the court does, I'm sure the other side will appeal. So I think this case is either going to go forward in the Superior Court or it's going up to the Court of Appeals.
And Jon, when you say the other side, you're talking about the state of North Carolina, because the case is against the Department of Health and Human Services.
That's right.
Right. And there are other organizations, in addition to the John Locke Foundation, national organizations have taken an interest in North Carolina's Certificate of Need laws. Why?
Because this is a problem all across the country. There's still con laws in place in 35 states. I believe that's the number. Everywhere they're there, they're harming the public, they're raising costs, they're reducing accessibility, and they're violating people's rights. What happens in North Carolina is going to be important all over the country.